Hi friend, welcome to the company law education and appeal series. Today we are discussing Hyderabad ROC adjudication order for the violation of section 135 of the Companies Act, that is the delayed deposit of the unspent CSR fund in a federal bank. In this case, the penalty imposed on the company, that is the twice the amount of the default, that is the total penalty imposed on the company and officer in default, that is the 92.18 lakhs. Let's see the facts of the case. Company having registered office at Hyderabad, and company and along with the officer in default has filed a suo motu application for adjudication of the violation of section 135 subsection 6, read with the section 135 subsection 7 of the Companies Act, taking necessary orders. It is submitted by the petitioner that the applicant company pursuant to section 135 subsection 6 of the Act was required to transfer the unspent amount of the 42.9 lakhs of ongoing CSR project to a special account to be opened by the company in the federal bank to be called as unspent CSR account within a period of 30 days from the end of the financial year on or before the 30th April 2021 for the financial year 2020-21. However, company has failed to transfer the said unspent amount to unspent CSR account of the company within a period of the 30 days from the end of the financial year. It is on or before 30th April 2021, resulted in violation of section 135 subsection 6 of the Companies Act, liable for the penal action under section 135 subsection 7 of the Act. Further, applicant company has submitted that it has transferred the unspent amount of the 42.9 lakh to unspent CSR account on 30th September 2021. It is a delay in the transferring of the unspent amount. This is a default. Since the company has made good the offenses by transferring the unspent amount to unspent CSR account of the company has and prayed to pass an order for the adjudicating the offense under section 135 subsection 6 of the Companies Act. And let's see the provision of section 135 subsection 6 of the Companies Act. This section says that an amount remaining unspent on ongoing project fulfilling such condition as prescribed undertaken by the company in pursuance of the CSR policies shall be transferred by the company within a period of 30 days from the end of the financial year to a special account to be opened by the company in this behalf for the financial year in any scheduled bank to be called unspent CSR account. And subsection 7 of section 135 says that if company is in default and complying with the provision of subsection 5 or subsection 6, the company shall be liable to penalty of the twice the amount required to be transferred by the company to the fund specified in schedule 7 or the unspent CSR account as the case may be, or 1 crore rupee, whichever is less, and every officer of the company who is in default shall be liable to penalty of 1/10 of the amount required to be transferred by the company to such fund as specified under schedule 7 or unspent CSR account as the case may be, or 2 lakhs rupee, whichever is less. This is the penalty given in section 135 subsection 7 of the company. And a reasonable opportunity of being heard was given to the company, and the authorized representative attend the hearing and give oral submission that the company has complied the provision of section 135 subsection 6 of the Companies Act, transferring an unspent amount to unspent CSR account on 30th September 2021. Since the company has made good the offenses by transferring the unspent to unspent CSR account, authorized representative has paid to take a lenient view as the delay was not intentional and application has been filed voluntarily. After considering the submission made in the application and the authorized representative and the facts of the case, it is proved beyond doubt that the company and officer of the company have defaulted in the complying the provision of section 135 section 6 of the Act. In this regard, it is noticed that adjudication officer has no discriminating power to reduce the fixed penalty provided under section 136 subsection 7 of the Act, and therein the company and officer in default within the meaning of section 2 clause 60 of the Companies Act are hereby directed to pay the following penalty from their own sources. Having considered the facts and circumstances of the case, here penalty imposed on the company, that is twice the amount required to be transferred by the company to the fund or unspent social responsibility, corporate social responsibility account. That is a 42 lakh 9,263 multiplied by 2. That is the total penalty imposed here is 84 lakh 18,526 or 1 crore rupee, whichever is less. Here 84 lakh 18,526 is the less amount imposed, penalty imposed on the company. And officer in default, there is the 1/10 of the total unspent CSR fund. Here 1/10, that is the 4,20,926 on this officer in default, this director, and 2 lakh rupee, whichever is less. Here 2 lakhs is the less, that is the 2 lakh each on the officer director officer in default. It's the on for the director there are 8 lakh rupee imposed on the directors total penalty imposed here is 92.18 lakhs. In this case for violation, the penalty as indicated shall be paid within 30 days from the date of issue of this order by the defaulter out of their own resources and file the form INC 28 with the office of the ROC. In this regard, attention is also drawn under the provision of section 454, subsection 5 and 6, which contemplate any person aggrieved by an order made by the education officer may prefer an appeal to the regional director having jurisdiction in the matter within 60 days from the date on which the copy of this order made by adjudicating officer is received by the aggrieved person and shall be in such form, manner, and accompanied by such fees as may be prescribed. Let's see if a company applied for the appeal, then we see the appellant copy and appellant authority view on this adjudication order. Thank you so much for watching this update. This order was passed on 22nd February 2023. Thank you so much.